Okay, hi. I have a panel of distinguished New Yorkers, which is great. Nobody had to cancel. Nobody's calling it in. No pun intended. So I'm very happy to convene this final panel on pro bono representation and right to counsel and some of the advances and challenges in both. You've heard a little bit about these topics tangentially over the course of the day, but I'm very happy to have three really eminent members of the New York Bar who have all been working on these issues in particular very deeply and intensively for many years. To my right is Lynn Kelly, who's the Executive Director of the City Bar Justice Center, which is the pro bono arm of the New York City Bar Association. Longer, more detailed, very impressive bios of everybody are in your materials. Rachel Tiven, to Lynn's right, is the Executive Director of the Immigrant Justice Corps, which I like to think of as a kind of Peace Corps for new immigration lawyers. It's one of many initiatives that grew out of the work that Judge Katzman did, bringing together members of the New York Bar to address issues in capacity building in the immigration bar in New York City. And to my far right, needs no introduction here, Peter Markowitz from Cardozo Law School, head of the famed Immigration Justice Clinic here at Cardozo. What we're going to talk about here are pro bono models and advances in general. In particular, examples of new service delivery models, which the three panels here are all real good examples of the programs that they lead. Involved in creating new service delivery models is increasing the capacity both of existing organizations and of just the immigration bar, especially the pro bono and the nonprofit bar in general. And of course, what this is all connected to as well is working toward a right to counsel for immigrants, for people in immigration proceedings. We obviously do not have a statutory right nor a constitutional right to counsel in immigration proceedings, which still astounds me. You know, when you hear the stories that we've heard today about the punitive measures that people are subject to that are not considered criminal or punitive in nature, and that you have children expected to walk into court and represent themselves, essentially, it still kind of shocks the conscience as far as I'm concerned. But we have some really good models here in New York for addressing some of these issues, and they're scalable models that can be replicated, and I think people elsewhere in the country are already trying to do that, to replicate some of those models in other jurisdictions. So we're going to talk a little bit about, well, the large group pro bono immigration clinic, that's an established model. Places like the City Bar, ALA run these things all the time, where you designate a day, you get a bunch of pro bono volunteer attorneys to come in, you have clients coming in knowing that this is a U visa clinic, and if I'm a victim of a crime, I've heard I might qualify for a U visa, I can go to this clinic and a lawyer can help me. Or there's, Citizenship Day, I'm a permanent resident, I've been here for 5 or more years, I can apply for naturalization, I can go to this clinic and get some help on that day. That's pretty well established, and they run pretty well and pretty frequently. People like Danielle Isaiah, our Fragomen fellow at the City Bar, runs a lot of these kinds of clinics, and a lot of people in this room run and participate in those kinds of clinics as well. Major law firms that are involved in pro bono have long focused on immigration in many cases. It's an attractive kind of practice for pro bono for a lot of reasons. For one thing, if you're a litigator and you're in a huge firm where you might not actually get into court for several years normally, taking on an asylum case gets you into court, although not that quickly necessarily these days, and that's an issue too with the long adjournment dates in the immigration courts. But those are pretty well established pro bono programs as well. Some new exciting things have been happening with these so-called low bono incubator programs, like the program out of Pace Law School, where they're assisting people to set up their own practices. At Pace in particular, they're focusing on immigration, but some other law schools are doing incubator programs with other areas of law as well. But they help people to launch practices where they can't necessarily afford to give pro bono services, but they can give so-called low bono, low-cost services, and those are kind of exciting programs. Something fairly new that Lynn Kelly is going to talk about are corporate in-house legal departments that have been partnering with pro bono or with nonprofit organizations to create clinics of a certain kind for immigration cases. We have the great new service delivery model pioneered by the Immigrant Justice Corps, where new graduates from law schools are trained and placed in existing organizations that already have some expertise and capacity in the immigration field, but they are able to, in some cases, maybe double their capacity overnight by the placement of a couple of fellows. And we also have, of course, the New York Immigrant Family Unity Program. I always get that long acronym mixed up. It's a mouthful. That's pioneered by the Immigration Justice Clinic and others here in New York City. Again, a lot of this growing out of Judge Katzman's inspiring initiative. So I'm going to ask first Lynn Kelly to talk a little bit about some of the programs that she oversees at the City Bar Justice Center.
Thank you, Careen. It's really a remarkable day. I'm still recovering from some of the rough justice we've been hearing about. And I'm wondering how many in this group are working with organizations that have pro bono programs. Can you just raise your hand if you're... So we have a lot of familiarity in this room with pro bono. So please, feel free to ask me questions if I'm sort of going too quickly or you don't understand what we're talking about, because I feel like it's a relatively sophisticated audience on the pro bono topic. So rather than go over too many basics, I thought we should jump in with some of the more interesting developments. So in New York, I think you know that our recently retired Chief Judge Jonathan Littman made pro bono a real priority. So one of the things that he did, he made a number of changes to increase pro bono, including the 50-hour requirement for new graduates. But what he also did is he created a registration program for corporate lawyers that may be licensed elsewhere. And that was part of an effort to really get more corporate attorneys to do pro bono. What's happened is in-house legal departments have grown. It's one of the developments of our time. They're developing their own legal departments, partly to keep down their outside billing fees. And so you have legal departments and corporations that are beginning to look more and more like an outside law firm. And they're beginning to do more pro bono. So partly through Judge Littman's efforts, but also just partly because they're getting bigger and they want to give back to the community, and they want to do pro bono for some of the same reasons that law firms do it. So we're finding interest for the first time, really, in corporate in-house departments in doing pro bono. And so that has some really interesting potential because we're all sort of looking at ways, how can you bring more lawyers in to the immigration field and therefore help more people, right? That's really kind of what we're talking about here. And as Careen said, none of us think this is a substitute for a right to counsel in this area. And in fact, the New York City Bar Association, where my office is part of the sort of nonprofit sister program of the New York City Bar Association. They're already on record with supporting a right to counsel for immigrants in removal proceedings. So no one thinks this is a substitute for staffed lawyers at a legal program doing this work, but in the meantime, we're really looking for all hands on deck. Where can we get every possible resource to throw at this problem? So in-house legal departments, I would say, are one of the sort of emerging issues in pro bono, and that has that has resulted in even more unbundling of legal issues. And so what you'll have in-house legal departments. Many of them do not want to get engaged on like an asylum case that's going to take 3 to 5 years. They're just not going to do it. But they will do a TRU visa clinic where you carefully screen the clients, set the cases up, they'll do the interviews, they'll fill out the paperwork, and then they'll give it back to the pro bono organization to finish the processing. So it really is, sometimes I think of it as like a bucket brigade. We're moving these cases down a row, and it's pretty well developed in the pro bono field of immigration that we do what's called bookending, where you have substantive experts on the front end making sure the case is being properly screened into whatever the relief clinic is, and then you can have Wall Street lawyers or corporate lawyers who don't necessarily practice in this field all the time, and then you have substantive experts on the back end. The other option are clinics that are done with immigration experts, people from Fragomen. AILA does a huge number of these. Law firms like Frank have substantive immigration experts internally at the law firms, and may even do practice in that area. But you have to have really experienced immigration lawyers properly identifying the legal issues, or it really is not an appropriate pro bono project. And that's why people are pretty careful about how they put these things together. We really want to make sure that we are picking the right remedies. Have all heard today, and those of you that are substantive experts in the field know how complicated immigration law is. I mean, it's very, very complicated. People have multiple layers of things they may be eligible for, and some of what you're doing is trying to pick the best of the options. And then sometimes they don't have very good options, and you're trying to pick the best of the options among poor options. So I think the corporate legal department pro bono programs are interesting because it's new, it's extra resources, and also there's an interest in law firms in partnering with corporate legal departments. So we sometimes do clinics which are partnerships between a law firm and a corporate legal department. And interestingly, in those situations, it's usually the law firm who will walk out with the case if there's extended work that needs to be done, because in a sense, they are also vendors to the corporate legal departments. They sometimes do their outside legal work. Some of the issues that we've seen with corporate immigration pro bono practice, there are just basic timing issues. These tend to be transactional lawyers. They're usually not litigators. So if there's anything that has to be done in a rush or a hurry, not usually a good match. Logistically, the corporate legal departments usually don't carry malpractice insurance. So there's some very basic things that you have to really talk to them about and figure out who's going to cover the malpractice insurance on anything like a clinic that's held there. My office covers the malpractice on any case that we screen and place, and so frequently, you just have to make sure that there's some entity that is going to cover the malpractice. There are space problems for some of these in-house corporations. Things as simple as if they want to hold it at their office. We've had clients be unable to get upstairs. They don't have the right ID to get through the security desk at the front of the building. So you have to, you just have to think through the nuts and bolts on this. And then there's language capacity issues. All of the folks that are in the room that serve immigrants know that you have to have translators. You have to set these things up so that it's possible for people to do the interviews. Corporate legal departments do not necessarily have translators, although some of them enjoy bringing in more than just the lawyers, and they like to have paralegals and their own support staff involved in translating. So I think that, from our perspective, that's a positive legal development. We're excited about doing more of that work, and I think it's a potential place where we can get more help. The increased volume of unrepresented pro bono cases, or immigration cases right now, is affecting pro bono. The law firms have been heavily tapped by the incredible need to represent children right now. And so people are feeling very tapped out. The people that I talk to are saying that they really can't take on anything else. Some of those cases have thorny ethical issues, which have placed demands on both the placing organizations and the law firms to figure out who's the client, how do they represent children, what's the age issues involved in that. And then because of the way that docket has gone to the front of the line, established pro bono fields like asylum are getting backed up. So you have situations where it's taken 1.5 to 2.5 years for affirmative cases, 3 to 4 years for removal hearings, unless they're on a surge docket, and there's a backlog in new adjudications. We now have 18 months to get to an adjudication or request for evidence, and then could be up to 3 years for full approval due to the visa cap. So it creates a need on the part of the placing organization to be more involved in these cases. And in some cases, the term in our industry is called unbundling. And it means that that you're giving out a piece of the work to be done, but you may be taking the rest of it back. The traditional pro bono model and sort of the traditional way that those of us who've been lawyers for a while did the legal work was it was a full representation model. And you sort of took the case and you did whatever it took to get it done. There's a lot more unbundling going on now, and firms are increasingly asking for that. And it's partly because of turnover at the law firms. The law firm themselves have associate turnover. So you could end up with an asylum case that ends up with 3 teams having to be oriented and to interview the client before the thing actually goes to a hearing and results in a decision. And that is a huge burden on whoever at the firm is coordinating their pro bono docket. So I think the delays are a huge potential emerging problem on the pro bono front. The good news is that pro bono at this point in the law firm community, and I'm talking like the top law firms that do this work, and some of these very, very large and established immigration firms, it's been built out now for about probably almost 20 years, and they have professional pro bono coordinators at the law firms. They themselves have become experts in some of the areas that they supervise. So they know a lot about immigration, they know a lot about asylum, and they can help kind of smooth out these changeovers in personnel. Otherwise, it's a big problem because it's not very efficient. There's an efficiency problem with having to, constantly orient people to the facts of a case and get it ready when it's not going to go forward. So some of the other thoughts I would offer on this is I think that one of the reasons that immigration is such a good area for pro bono is that the firms tend not to have conflicts because the defendant is a government. And so they're, unlike doing foreclosure or some of the other areas that I practice in, there's usually not a conflict. So that makes it a very good area. The complexity of immigration, your organizations and the immigration experts in the room help to make that more palatable just by screening the cases carefully. The large due process issues of the day that we're talking about, I think the law firms can also be helpful on, especially because when I look at the sort of challenges of the issues we're talking about, it just seems like we're accepting a very rough justice, like a level of rough justice that we would not accept in other areas. And I'm running a new program at the Eastern District of New York, which is we're basically running the federal pro se litigation office for the Eastern District right now, and that has caused me to look at a cohort of about 250 cases, which are civil rights cases, prisoner cases, and then a bunch of other cases, all in the civil area. But the criminal system isn't working so well either, right? And the prisoner system, which despite the 75 years of litigation in that area, we still have people that aren't getting medical care in regular prisons. So I think, for me, today's presentations on due process have really tugged us toward looking at why aren't we litigating for a right to counsel in this area. People have picked off, mental health issues, children's issues, but, the expedited removal hearings, the number of people where it appears that there may be errors in the adjudications, which is part of the due process analysis. I have been binge watching The Making of a Murderer, as I'm sure many of you have. And, I in some sense, I feel like it's going to take something like that to tell this story. I think the reports are just too complicated for the public. It cannot be just the wonky, immigration experts talking to the other people who get these levels of complexity. I think there has to be some simple stories told about what this means to families where there's been an error, and then we have to move forward. And I think pro bono can be a piece of this. The law firms have enormous resources, and they're incredibly committed to due process. The lawyers all agree on due process. We all agree everybody deserves a lawyer. There's like no dispute about that. We all agree on that. And they can be helpful on those kinds of cases. But I think the challenge of sort of simplifying the stories down so that people get that this isn't who we are as a country and this is all unacceptable, I think it's got to be told in a different way than we've been trying to tell it.
Thank you, Lynn. That's great. You know, for the law students in the room, I think you're very lucky that, at least if you're going to be applying to New York Bar, that there's now a 50-hour pre-admission requirement for pro bono hours. You may think it's a burden, but I actually think it's a really good development, and I hope other states copy it, because I think it will help set the habit from the very beginning of your careers that pro bono is something that's important to do. Our firm, for example, Fragomen, we've always been very active in pro bono, but we were inspired by that to create our own internal 50-hour per year pro bono requirement. And even at a firm like ours that was already very active, you always had people that did one case and they left and they came back for more, and you had the same people coming back, and you had others who were like, oh, I don't have time, or I'm not sure if I can put in the hours, or if my boss will want me to put in the hours. And now it's becoming just an organic part of the culture for everybody that, although we are an immigration law firm, we do mostly employment-based immigration, it's important that we also do the public interest immigration work as well. And I hope that that kind of thought process and mentality spreads to other firms as well. Rachel, could I ask you to tell people what the Immigrant Justice Corps is, for those who don't know, and for those who do know, what have you done this last year? What are your accomplishments?
You hand me the clicker, I'll click myself forward. All right. Well, thank you, and thank you for the inspiring charge, Lynn. It's interesting to think about the framework of today's conversation about new service delivery models, and certainly the service delivery model of Immigrant Justice Corps owes a lot to Peter Markowitz, my predecessor, and to lots of people in the room who consulted on the development of the model and who have participated in training Immigrant Justice Corps fellows now for 2 years that we've been running the program. So we are in our second year. And what Immigrant Justice Corps does is to recruit and train and deploy the most talented, committed, and prepared new lawyers and college graduates to serve poor immigrants in and around New York City. And a lot of our fellows are in the room. If you're an Immigrant Justice Corps fellow, will you raise your hand? So we have a lot of right. Well, they sit in the middle for their monthly meetings. They want to sit inside. But Immigrant Justice Corps fellows have come from around the country to New York City. About half the group are native New Yorkers. About half the group have come here from elsewhere to do this program. And one of our goals was really to create a pipeline for first-year lawyers. Right, because so many of our nonprofit agencies can't afford to hire someone right out of law school and to put in the effort to train them and to really begin that person's career in the field, the goal of the program was to create that initial pipeline so that people who wanted to do immigration could come out of law school and go right into a prestigious fellowship that would help to prepare them and to support them in the beginning of their career, so that at the end of a 2-year fellowship, they're a third-year immigration lawyer with really a lot of skill and a lot of experience and very highly employable locally and nationally. And when our first class concludes at the end of August, we will be able to report on how the placement of those fellows is going. But we're very optimistic that they will continue in the field and will continue to really be the next generation of immigration lawyers. The other piece of the program is for college graduates. So every year we have 25 new people. There you go. Every year we have 25 new lawyers and 10 new college graduates. The college graduates become Board of Immigration Appeals accredited representatives, so they are able to advise people on what their immigration opportunities are and to help them file affirmative applications to improve or upgrade their status. And like our law graduates, our college graduates are highly prepared, extremely selective program. We had 20 times more applicants for the Community Fellows program than we had slots, and really extremely motivated and experienced in immigrant advocacy. So the people that are coming to us with really terrific preparation, but we are kind of creating a pipeline for them to go into the field and stay in the field at a high level. what we also get to create is a kind of laboratory, right, with 70 fellows in the field at a time, right, 50 lawyers and 20 college graduates at any given point beginning this year, now that the program is at full capacity. That's a lot of petri dishes, right? And we're able to run a lot of experiments and see how our fellows are able to be maximally effective in all different kinds of settings, and really to deploy them to nonprofit agencies around the city. And this year, for the first time, we were able to expand the program to reach drastically underserved communities in Long Island, the Lower Hudson Valley, and northern New Jersey. And we're really excited to be able to bring services to communities that have been woefully under-resourced, even though for many of them they show up in the same immigration court as New York City residents. So there was no sense to us that you could have two 17-year-olds sitting next to each other on a bench at 26 Federal Plaza, and one of them, who was released to an aunt in Queens, was going to have a lawyer, thanks to the largesse of the City Council and Robin Hood and New York Community Trust and all kinds of pro bono efforts to provide counsel for unaccompanied minors, and another kid from the same, could be from the same town with a very similar fact pattern, released to an aunt in Nassau County, was not going to have a lawyer. So we've put a lot of resources into expanding Immigrant Justice Corps beyond the 5 boroughs. But that kind of gap filling is something that we found has really been an exciting opportunity, because for a lot of the really extraordinary local hosts with whom we partner, the 30 different agencies that host Immigrant Justice Corps fellows and supervise them and provide a day-to-day structure in which they do their work, we're able really to build on the richness of their experience, but also to provide some gap filling between different contracts, different obligations. Our fellows are able to really help them cover what the actual need that walks in the door is. So that's really been pretty exciting. And our fellows are I am biased, but Peter can kind of share my pride in just an incredible group. They are multilingual. Half of our fellows are first-generation immigrants themselves, 1/3 men, 2/3 women, and really from the best schools around the country and around the city. Almost every local law school is represented among our fellows, including Cardozo, very, very well represented, and we're also very particularly proud that this year we had as many fellows from CUNY as from Harvard or Yale. So really terrific local representation and terrific national representation in the program. So what did we learn in year one? Our community fellows. So 10 community fellows in the first year. We piloted at 5 agencies, 1 in each borough. And what we found was that they were able to do in those local agencies, in the community-based agencies where they were placed, which were places that did not have immigration law staff already in their agency, right? We wanted to put the community fellows at places that had local cred and local trust with the population that they serve, but that had not previously been providing immigration law help. And so we picked 5, and we had a theory based in part on the experience that we all saw in screening for DACA, that perhaps there were people who were eligible for some kind of upgrade in their status if only someone could do a real full diagnostic and find out whether there was something there for them. And so what we found is that about half of the people we screened were eligible for something, and about half of them were not. Right? To break it down very roughly, we found that a quarter of the people we screened were not eligible for any improvement in their status under existing law. They were undocumented and had no way to get into status, even with the best immigration lawyer in the world, because the law does not currently provide any mechanism for them to do so. About a quarter of the people we screened were eligible for the President's Deferred Action Plan, most of them for deferred action for parents, some for expanded DACA, but obviously that is currently unavailable. And then about half of them were, at least on paper, eligible for some improvement in their status. And so we were able to file applications on behalf of 27% of the people that we screened. The balance are in process, or were eligible for something but not yet ready to move forward with their filing, or are being screened for some more complex form of relief. But at the end of the day, we filed applications for 27% of the people of the 2,333 people that our 10 community fellows screened last year. And here's what we found. Of the 632 applications we filed, they broke down as overwhelmingly naturalization and green card applications. Some of those green cards are renewals, some of them are new. Likewise, DACA and TPS, some new, some renewals. And there obviously are some terrific benefits to that, in addition to a reasonable bump in lifetime earnings power on naturalization. Obviously, the most important value of naturalization is protection from future removal, and the ability. I mean, I think voting's good if you do it, but not showing up as a client at anybody's organization down the road, when if only you had naturalized earlier is obviously a huge, from the immigration lawyer's perspective, a huge bonus. And so that was very satisfying. We learned some really interesting things about that population of NATS applicants. We had terrific uptake from our Chinese New Yorker serving placement. Chinese American Planning Council in Brooklyn and Queens represented more than its share of our naturalization clients. So there's an enormous demand from the Chinese community. We also did a lot of fee waiver applications there, and and that, I think, that work in particular is that is direct poverty fighting work, right? Our clients are the working poor, people for whom saving $600 in application fees, saving the work of, saving the exploitation of paying someone, even for something, like a green card renewal. We've had lots of conversations about, well, what's the value of a green card renewal? Well, if you were going to pay someone $1,000 to do your green card renewal, because that was the only option that seemed like a safe one to you, then an Immigrant Justice Corps fellow doing it for you for free and filing the fee waiver application along with it really is food in your family's mouth in a way that has enormous value. So that it's really interesting to see what we have there, and also tremendous demand from Mexican New Yorkers, but too few routes into status compared to our Chinese clients, or frankly, people from almost every other country have more opportunity to get into status than Mexican New Yorkers. Our Justice Fellows. Our Justice Fellows in year one were able to open, collectively, 969 cases. So that's 25 fellows placed at a dozen different agencies around the city. Some of the most august and well-respected immigration agencies that we are lucky to have here, where they really got terrific training and did excellent work in their first year. We surveyed the agencies to ask them, are these all new cases? Are these cases you couldn't have taken otherwise? Which seemed obvious to us, but we wanted to check. So all of the hosts replied that yes, almost all of these were cases that they certainly would not have been able to take otherwise, that would have sat perhaps on a waiting list, but that they were not otherwise going to be able to serve. So that's almost 1,000 new clients served in year one. About half of those are affirmative and half of them are defensive. They break down in the case types you see here, which I think is really interesting just to see the variety of VAWA and U's and T's, of SIJ, of asylum, also of removal defense, cancellation of removal, and other kinds of bread and butter removal defense work. But overall, among all of those types, about half were affirmative and half were defensive. And that's really a reflection of the unique situation that we're in here in New York City, that because of NIFUP, which Peter's going to talk about, we are able to put resources toward the kind of complex affirmative humanitarian cases, asylum, SIJ, U applications, that if it weren't for the funding that NIFUP has to serve people who are detained, then almost certainly about half or almost all of Immigrant Justice Corps' resources would go toward representing people who are in defensive removal proceedings, detained or non-detained, because obviously those are the most urgent of the cases that are out there. But because in New York we are lucky to have additional sources of support from city government and from private funding, that we're able to go deeper into this bucket of people who have a valid claim to eventually become citizens, but based on a very complex application that would almost certainly be impossible to do without representation. The good news is that of the cases that closed, 98% of them were successful. Bad news is only 6% of the cases closed. So for the reasons of we have been discussing and are all well aware, the extraordinary delays and really unconscionable backlogs make it very difficult for the cases to move forward. It's easy to open them, but it's hard to close them. It's an untenable situation. It is ridiculous that in a 2-year fellowship, a client you meet on the first day of your fellowship may not be able to resolve their matter by the end of your fellowship 2 years later. And we have been lucky that New York Immigration Court has been supportive of this program and eager to try to accommodate our fellows in getting individual hearing dates within the term of the fellowship, but that obviously is not a sufficient solution to what is truly a structural problem. We would be happy, by the way, and I want to be clear, and I try to say this every time I speak publicly, I would be very, very happy to put all of the defensive work we do completely out of business. The program would be very cheap if the government were not detaining and deporting so many people. And it would be far more effective for the attorneys and BIA-accredited reps that we train to be walking people along a path to citizenship than to be defending them from removal. Lastly, our clients. A little bit of a snapshot of where our clients come from. They are loosely representative of the demographics of New York City, the exception being the overrepresentation of Mexican New Yorkers, our fastest growing group, but strong showing from the Dominican Republic and from China certainly reflects the biggest immigrant groups in New York City. The average household size of the clients represented by our Justice Fellows was a household of 3. 45% of our clients were employed, 55% were unemployed, retired, or students. 42% of them are high school graduates or more. And 68% of the clients represented by our Justice Fellows had never seen a lawyer before. So really gives you just a sense of what the need is. We are excited to be providing such excellent service and to really be seeding the future of the immigration bar in New York and nationally, and really to be making an impact. But we really look forward to being part of broader structural solutions that will change the picture of who we represent and in what kinds of matters.
Thank you, Rachel. So, Peter, you mentioned in your opening remarks that New York City has the country's first public defender system for detained immigrants.
Yeah, I heard something about that. Sure. Sure. Okay, well, first, it has been a really both kind of daunting in some ways, but inspiring in a lot of ways day to hear all of the panelists that came before. It's been a really tremendous round of presentations, and really an honor to sit on a panel with this group of people who have been kind of critical to advancing justice for immigrants in so many ways for so long. So nice to be here at the end as well. And thank you all for sticking around. So my charge is to talk a little bit about the New York Immigrant Family Unity Project, the first public defender system, a little bit about its successes and how it came to be. But I know some people in the room have heard that story before, and so I want to go beyond that and talk also kind of about the real challenges to growing and replicating that project, and ultimately towards moving towards a national public defender system for immigrants, a national right to counsel. I want to take seriously the charge that Lynn gave us, that kind of the idea of a right to counsel has been thrown around a lot, kind of aspirationally today, but it won't happen just because it's our aspiration. We have to have like a plan and a strategy and a path, and I want to talk a little bit about what I see as that path. But first, how did we get here? This story, as with many of the stories today, starts with Judge Kathryn. Let me do that. Yeah, something like that. This story starts with Judge Kathryn, and his study group kind of obtained a very small grant several years ago, and there was a discussion among some of us about how best to utilize that grant, and we kind of decided that our principal kind of criteria were we wanted to really tangibly move forward access to justice for immigrants in the short to medium term, but we also want to do something that will be an important step towards our long-term goal of a right to counsel. And it was from there that we came to the New York Immigrant Representation Study. Judge Kathryn is kind of fond of saying everybody's entitled to their own opinions, but not to their own facts, and once you have the facts, that will drive policy. And so the idea behind the New York Immigrant Representation Study was to do more than share our intuition about the gravity of the immigrant representation crisis, and particularly the way it affects detained immigrants, but actually to have the data to back that up. And I can't say that we were entirely surprised, but what the data showed us was that the epicenter of the immigrant representation crisis in many ways were detained New Yorkers facing deportation. And I call it the epicenter not to say that anything else in terms of the immigrant representation crisis lacks import. It certainly doesn't. But the consequences to individuals and to families of actually being physically detained, the consequences of potential lifetime exile from your home, from your family, from your livelihood, the fact that 60 to 80% of detained New Yorkers had no counsel whatsoever as they litigated in this very difficult arena against government lawyers, and the fact that they had virtually no chance of success without a lawyer. Only 3% of unrepresented detained respondents prevailed in our data set, and contrast that with the folks who were out and fighting deportation with the assistance of attorneys, and about 74% of those people were winning. So being locked up and not having an attorney was kind of where we decided to put our resources. We decided that we needed to move towards a government-funded program pretty early on in the process, because when we started looking at what role is pro bono and nonprofits and law school clinics playing in this population, while it was critical and important the role that they were playing, it was small. There were only 2% of the folks who were detained in New York were represented by pro bono law firms. Less than 1% were represented by nonprofits and law school clinics. So the idea that we could scale up those programs through their traditional funding sources and meet the need was a pipe dream. We knew we couldn't do it, and we knew that if we wanted to build something sustainable that really met the full need, it was going to have to be a government-funded program. And so we honed in on that fairly early on. We also, and this was after much discussion, there was a steering committee. Lynn was on the steering committee, and many other people in the room were on the steering committee that looked at the data and tried to say, what's the most ambitious thing that we can design that meets those short-term and long-term goals that I identified previously? And there was a long discussion about whether our resources were best deployed in a kind of screening triage model where we could identify the cases where we're most likely to shift outcomes, or whether we should be moving towards a universal representation program, meaning no merit screening. If people income qualify, if they don't have an attorney, they get one. And ultimately we landed on the latter system, and we did anybody has an untapped bottle of water, I would love that. And we did that because, thank you very much. We did that for two reasons. We did that mostly because we had our eye on the prize. We really did want to be deliberately working, thanks, Dave. We really did want to be deliberately working towards the goal of a universal right to counsel. And we thought if we don't start there, we don't end there. And so we were committed to starting there for that reason, but also on a much more practical sense. We had a lot of expertise in the room making these decisions. And while screening and triage is, frankly, the best available way to determine how to allocate scarce resources sometimes, it's not a very good way. Meaning that until you do kind of an in-depth factual investigation of your client, looking at their criminal history, looking at their immigration history, looking at their family history, sometimes you're blind to defenses that might be available. So both for kind of goal-oriented reasons and very practical reasons, we decided on a universal representation model. And once the study came out and the proposal was made and we got some good press, it was really gratifying to see that the immigrant rights community, who weren't necessarily even the kind of steeped in the legal community, kind of rose up and said, we need to make this a reality. The Northern Manhattan Coalition for Immigrant Rights, the Make the Road New York, the Center for Popular Democracy worked together with our clinic and with Vera to take this vision and turn it into a reality with the City Council. And we were skillful in some ways, but we were very lucky in many ways to have partners like the speaker, Melissa Mark Viverito, who has made this an absolute priority and, has almost single-handedly ensured the success of this program by institutionalizing it year after year. So it started, right, with a pilot in fiscal year 2015, relatively modest, $500,000, but then quickly went in fiscal year 2015 and re-upped again last year, 2016, and we anticipate it will continue forward at full funding, around $5 million per year. And we were able to implement this. Sometimes when I go around and talk to folks around the country about trying to replicate this, one of the questions that they have that kind of stymies them is, where's the infrastructure to actually provide this representation? Even if we could do the heavy lift, the political lift to get the money, who's going to do it? We were lucky in New York to have public defender offices with really robust immigration units, the Bronx Defenders, Brooklyn Defenders, and Legal Aid Society, that had not only been had robust Padilla-type units, but had actually been doing detained removal defense for some time, and frankly were ambitious and eager to meet the challenge. And the success of the program really in large part is due to, how many folks are here from one of those offices, by the way? It's like a bunch of people, right? Those are the reasons why this program, those people are the reasons why this program has been successful. It was fun to kind of write the proposal and get people to fund it, but then we're like, all right, now go do it. And those guys have done the heavy lifting of carving a path. They're not reinventing the wheel, they're inventing the wheel. This is the first public defender system for immigrants. And there is a huge learning curve, and the lift of going in and taking every case that comes with its initial master and following through, no matter how difficult the challenge is. If your client wants to go to that individual hearing, you can get them there. You have to get them there because you're their attorney. That's not the world that any of us lived in before Knife Up. And the attorneys at those offices and the paralegals and the social workers and everybody else at those offices have really been the reason why this is successful, because they put their shoulder to the wheel and really done that. So we've served as actually updated numbers I was handed right before I went on stage. It's no longer approximately 1,500 clients and counting. It's about 1,700 clients and counting have been served. And they provide really wraparound services, some of which, frankly, are funded and some of which are not funded, but the organizations do them anyway, right? So they do all the immigration court level removal defense work, the bond hearings, the masters, the individuals. They also are funded to do the BIA appeals and the SIDG work in family court that necessarily comes along with it, and some social work services. But these organizations go above and beyond. They clear warrants and open criminal cases. They do post-conviction work. They do habeas work. They do all sorts of things that really makes for full wraparound services and makes for a very successful program. So how are we doing? We're doing pretty good. recall that the pre-program success rate for detained unrepresented folks was about 3%. Thus far, this data is all rolling in. We've talked a lot about the delays in these proceedings, and so because we've been successful in getting people out, about 50% of the people who were from the pilot phase thus far have been released, either because we won their case or because we got them released on bond or parole or the like. And what that means is once they're released, everything slows down, right? And so we don't have good results on a lot of the population, but the pilot population are the ones that have been going for the longest, and so we have some things to say about them. The cases that have gone to merits hearings, we've won about 70% of those cases. And it's important to remember that when you think about that number, who that population is, right? They're taking all comers. Anybody who comes in gets an attorney. And that means people with the weakest case you can imagine and the strongest case you can imagine. And if they want to go to a hearing, just like in a criminal court, if your client wants to go to trial, they go to trial. And so the fact that they're winning 70% of all comers is a pretty amazing success rate thus far. Apart from the benefits to the immigrants and their families, there's been real measurable benefits to the system as a whole as well. And this is one that kind of makes people feel a little squeamish sometimes. But one of the things that I see as a success of the program, frankly, is that a third of our cases are resolved on the first or the second master. And that's usually because people decide that they don't want to fight their deportation and they take the order. The reason why I see, or a voluntary departure, the reason why, which we count as a negative outcome, by the way, the reason why I see that as a success is I see those as people who, but for counsel, but for the provision of counsel who can expertly help them assess their chances of winning and come to a resolution at a very rapid pace, those are people who would have the exact same outcome, but instead of 2 masters in, they would have that outcome 6 masters in after 9 months in detention. And the fact that we have an unhappy outcome for those folks sucks. But an unhappy outcome for those folks and get them out of detention after a month is better than an unhappy outcome and get them out of detention after 9 months. And so the efficiency, I think, we often talk to policymakers about the efficiency gains for the court or for the detention system. We save lots of money for ICE because we get people out quicker. But frankly, the efficiency for the clients is the most important efficiency, it seems to me. And then there's also kind of benefits to to the extent we're getting 50% of the people out, we're winning a whole lot more cases. There are less families that are dislocated, less families that are losing a breadwinner, less families that are becoming reliant upon state and local safety net programs, and that's big as well. I don't want to lose track, though, of the kind of myriad of kind of intangible benefits that the program brings. I was talking with the heads of the 3 immigration offices recently, and they were talking about how important it is, how the wins that their attorneys often feel are the small wins that aren't going to show up in the data, right? We had the client who was set to get deported to Mexico, but actually they were from Guatemala. But for the intervention of an attorney, that would have been a really bad outcome, right? There's the folks who we can't stop their deportation, but we can get them out and give them 2 months with their family to wrap things up before they get deported, and that's really meaningful to them. And there are all sorts of small victories like that, connecting people with social services that have nothing to do with their removal case, but actually are critically important to the clients. And so there's all sorts of benefits that are flowing to this client population because of the diligent work of these offices. And not least of which is the feeling of kind of respect and dignity and power and voice that these attorneys in this program is giving to this population that has been kind of silenced for way too long. 2 other benefits that are hard to measure is really cultural benefits to the court. This is supposedly an adversarial system, but it's been an adversarial system for a long time without an adversary. And it's the court, the Varick Street Immigration Court, which is a short distance from here, is the court that I've appeared in more than any other court in my career. And to walk in now and watch the NIFA program, which I encourage folks to do, if you haven't done, you should really go do it. It's amazing to see the horrific dysfunction of that system that I was familiar with from when I was in there more often, turned into kind of the normal dysfunction of what I'm familiar with in the criminal court system. It's a huge step forward in the way that kind of the government is routinely put to its burden, and they're outraged that they have to actually prove up alienage or things like that. But those cultural changes are huge. And they're spinning off kind of really tangible things. We just had, as these attorneys are pushing the envelope on the law, that law is working its way up through the court and becoming, precedent from binding courts like the Second Circuit's recent decision in Laura establishing, right, that folks are entitled to a bond hearing after 6 months. That was because there was a knife-up client who had a knife-up attorney who decided to bring a habeas, right? That's how that case got there. And so the ancillary benefits to the development of the law from this program are really profound as well. Okay, so toward a national right to counsel. First, we are moving incrementally, right? We have replication programs up and running in several places. We have a small program up and running in Batavia, 2 years now, $100,000 per year, funded by the New York State Assembly. It's being run by the Erie County Bar Association Volunteer Lawyers Project. Again, on the same model, detained folks, universal representation, randomized because they don't have enough money to cover everybody, but they do know merit screening. This year, we got the Assembly to bump up their commitment for another $100,000, such that we were able to launch the pilot in a second site, the Ulster County Ulster Immigration Court, which is important because it's a very different population, in many ways the least served population. That's people who are currently serving prison sentences in New York and are part of the institutional hearing program go there. It's the place where the immigration representation crisis is most acute, and to have a pilot up and running there is a big deal as well, and Prisoners Legal Services is running that. And then there's a really substantial pilot from AFSC, in New Jersey. American Friends Service Committee in New Jersey has a multi-million-dollar 3-year or 5-year? 5-year pilot running at the Elizabeth Immigration Court, which doesn't quite cover everybody, but again, it's a universal non-screening model. So there's actual movement. This is like a building phenomenon. We're in touch with folks in many jurisdictions around the country who are actively trying to replicate this project. So lots has been done, and now let's talk about kind of how do we get over the hump? How do we get to that national right to counsel, the National Public Defender program? I think we get there. The next step, it seems to me, is going back to where we started. We need the data, right? One of the deficits of all the evaluations that have been done thus far about the impact to counsel, including ones that I was involved with, the New York Immigrant Representation Study, is that we don't have randomization in terms of the population that's represented, nor do we have good control groups. With the Knife Up project now representing everybody, we have a perfectly random sample, in fact, a complete sample. And we have the opportunity, because of VERA's unique access to EOIR data from other immigration courts, to do a true, rigorous, empirical comparative study that will, for the first time, be able to really tease out the impact that counsel has and control for the selection issues around counsel selecting cases they think they can win. So we, meaning my clinic together with Vera, are launching a significant study that will look at the full pilot data and the full 2 first years of data from the Knife Up program, and we'll have the first available data that will be able to really stand up to empirical scrutiny in some important ways. And we're going to be measuring not just the impacts on respondents and success rates and things like that, but also the efficiencies that are realized by EOIR, the efficiencies that are realized by the Office of Chief Counsel, the cost savings from decreased detention from ERO, as well as potentially, this is a little bit trickier, and so we're still teasing this out, potentially the cost savings to state and local governments around safety net services not employed. I think that's going to be a big deal in moving this conversation forward. When you start talking to national players and you need to convince folks like the Congressional Budget Office that this stuff really matters and can really deliver returns, you need data like that. And so having that data, I think, is one important piece of going forward. But the other important piece, I think, is something that Judy Rabinowitz mentioned on the panel earlier today, which is that these advocacy efforts really have to work in tandem with the litigation efforts. And ACLU and others have really been thoughtful about building an incremental litigation strategy around establishing a right to counsel. The first one is being mentally ill and taking advantage of the Rehab Act. And now they've moved on to the work with children that's been mentioned earlier today. If you look at the doctrinal kind of standard around when does the Due Process Clause require appointment of counsel, If you look at the doctrinal standard about when does the due process clause require the appointment of counsel, it lines up really nicely with detained removal defense stuff, right? The first factor is the nature of the private interest at stake. You can, have the longest string cite you want from Supreme Court precedent talking about, the deportation being equivalent to the loss of all that makes life worth living, and the gravity of the interest at stake is, there's hyperbole from the Supreme Court up and down about that. The comparative risk of erroneous deprivation, the study that we're going to be doing is going to show that it has a big, big difference. Right now, the preliminary data is telling us that out of every 10 people that we prevent their deportation, but for this program, 9 of them would have been deported. So we're looking at somewhere in the range of 1,000% increase in outcomes with the provision of counsel in this program. So we're going to be able to show counsel makes a huge difference. And in terms of the nature and magnitude of the countervailing interest, that's cost, right? And to the extent that we can show that the detention savings, which are going to be substantial, $159 a day, think about the 2 or 3 adjournments that are usually done to afford folks to get counsel and how much that adds up to right there. We're going to be able to show substantial, I'm not sure if it'll offset the entire cost of the program, but substantial offsets. And so doctrinally it lines up pretty well, but I think every litigator's intuition is, yeah, but if you run into court right now and ask for a right to counsel from any district court or the Supreme Court, universally, they're going to be, hesitant to do so, right? Courts, the Supreme Court in particular, are very cognizant of, is this a feasible thing that I'm ordering? Am I going to disrupt the system in some unrealistic way? And what history teaches us is that while it always seems unimaginable that you're going to get the next right to counsel, right? Gideon seemed unimaginable until we had it, and the idea that the Supreme Court was going to say folks have a right to advisals about immigration consequences in their criminal cases seemed unimaginable until we had Padilla. They seem unimaginable until they're realized, but if you go back and dissect those victories, what you find is that before Gideon, there were substantial state efforts in place, pilots, programs to appoint counsel. Before Padilla and the Supreme Court specifically referenced this stuff, there were substantial programs up and running delivering just those types of services, and the Supreme Court explicitly relied upon their existence in finding that right. It's a kind of if we build it, the Supreme Court will come story, and the efforts that we've been talking about today, right, about all the things that have been done to enhance access to justice for immigrants, every one of those, I think, moves us forward in a substantial way towards the right to counsel that we all desire and that we all strive towards.
Thank you, everybody. If you have questions, please line up at the mic, and while we're waiting for people to get in line, something you said, Peter, really struck me, which was the extent to which the government is now being put to its burden in immigration court because of the zealous advocacy that immigrants have, really for the first time. And it reminds me of something we've only touched on tangentially here, but that is the instance of fraud in representation of immigrants, often by members of their own community, by notarios and travel agents and fake lawyers and the rest. And I think that's a major benefit of all these programs, whether you're mobilizing pro bono lawyers or training new immigration lawyers like the IJC is, or creating the kind of program that you did, is that you're saving people from that kind of fraud. And that really can't be quantified. I wish we could quantify it. That would be good data to have, but that's hard.
I've been trying to quantify.
Rachel, when you talked about the 25% of cases that were green card cases, and I know some of those were renewals, I'm not sure what percentage of that 25% were renewals, but I'm really curious about the new green card cases. Is it your impression that these are people that didn't know that they qualified? Or was it that they just had never been able to afford to talk to a lawyer about it, or what?
It's a good question. I think in general, our fellows' experience, and our fellows in the room, especially community fellows who are doing screening for affirmative light touch applications, can also chime in and speak to this. I think that our experience is, by and large, not that people were unaware that they qualified for a benefit. I mean, we sort of have a joke in the office that that the fantasy is that someone walks in and says, is there anything you can do for me? And lo and behold, they have derivative citizenship, right? I mean, although we did have one registry case that is he just naturalized this week, or I mean that he was that I'm looking at Vicky. So every once in a while there is the needle in the haystack is located, but no, I think by and large it's people who knew they had something available to them but didn't have the opportunity to move forward on it.
Don?
Yeah, just a terrific panel. Thank you. Another one. It's been a great day. I didn't know that there were registry cases anymore. That must be the first one in years.
He's in his late 70s.
Yeah.
Is Asim here? No.
Yeah. It's lovely.
Yeah.
So I had a question for you, Rachel, which is I forget what the graphic was, but it was citizenship leads to economic, increased wages by 8 to 11% or something like that. Could you explain how you measured that and kind of what that, I think that was really kind of a powerful thing, and I didn't expect to see it in a.
It's not our statistic. It comes from some of the terrific research that my colleague Veon Behel at Robin Hood, the Robin Hood Foundation did, and I will find it and send it to you.
Okay, thank you.
It's a sort of a lifetime earnings bump that reflects sort of I think a willingness to take more career risk and to feel more permanence and to ask for a raise.
And Peter, you should go on the road. I mean, right? I mean, we're going to make you the czar of kind of federal public defender systems. That I'm surprised just looking at those numbers that 4.9 million does it. I mean that's not a huge number. I wonder if you could talk
the
about
providers
that.
would tell you that. Yeah, and actually the number is a little bit more. It was 4.9 in the first year, and we're a little over 5 million this year. And I think it doesn't entirely do it. Is the truth that the providers? I think it largely covers the cost, but there are two things that make it not the complete cost, and it's something that we're pushing on and we're pushing with the providers on. I think one thing is that they actually deliver services that they're not reimbursed for, right? I talked about some of the services that they do. But the other is we're trying, we kind of took a guess at the beginning about what's a reasonable caseload. I don't know, like we've never done a public defender system, and we sat around, we kind of guessed. And the environment has changed somewhat in New York. The detainer law that went into effect in November of 2014 really changed the population of who was showing up in the 9-foot program. And so that number of a third that's getting resolved on the first or second master, that number was 40% originally, and now it's down to almost 30%, and what that means is that's 10% more cases that need to be litigated heavily. And so things are shifting, and we're growing and learning, and we're advocating with the providers to make sure there's sufficient funding, but it gets us almost there, but not, frankly, all the way there.
This is where I think it's really important, right? It does not have to be this expensive. Right? When Bob Katzman got interested in the issue of unrepresented people who were showing up, right, or appeals to the Second Circuit that were fruitless, right, essentially, because there was no procedural avenue for a person to get relief when, had they been represented in their initial proceeding in immigration court, they might have had a good case and might have won. At that time, in 2001, there were 125,000 people in proceedings nationwide, and today there are 455,000. Right, so we would be happy to spend less money. I mean, this is right. This does not have to be this way.
Hi, I'm Michael Cooper with the New York City Bar Association. I chair our Committee on the Right to Counsel and Due Process for Migrants. And I, first of all, just wanted to thank you today. I really appreciated the panel. I found that often in this community we tend to sort of conflate the right to counsel with the need to counsel. So we often talk about how these folks, should have counsel, and they really need counsel because they're desperate for it, and it's a difficult system. And we less often stand up and say that they have the right to counsel. So I really appreciated the few comments that have been made in that direction. And Peter, your vision for the future, the long march that we have ahead. And thinking about that long march, I'm starting to wonder, who else should be in the room with us? You talked about sort of integrating our litigation strategy with our advocacy strategy. So I wonder if there should be anyone else in this room besides just us lawyers, just us chickens, as it were. Should religious organizations be here? Should unions be here? I don't know who else should be in the room. And I also think about the other kinds of services that we might need to pull together as sort of a long-term campaign. Do we really need to integrate this community with the services of a major PR firm or a media firm that can really help us think through what that strategy looks like? And it is a long-term strategy. It's not 3 years or 4 years. It's 10 years or 20 years for all I know. And to really step back and think how we can integrate everything that we know, bring the data into the picture, and then also add the other sorts of resources and expertise that we need to truly create, a campaign for this right to counsel, I think is something we need to start wrapping our minds around.
Yeah,
if you would agree.
Absolutely. I mean, I couldn't agree more with kind of thinking strategically about who are the constellation of allies we need to actually move this on a political level. Because the reason why we have this program, it was really nice that a group of lawyers did the study and came up with the kind of proposal of the model, but it would have died there, but for the fact that grassroots organizations that actually have political power, that actually the speaker cares about what they think, the mayor cares about what they think, picked up the mantle and Make the Road and Northern Manhattan Coalition for Immigrant Rights were much more important than the rest of us in actually unlocking the dollars. The kind of building power in immigrant communities and then making sure that the proposal that you're advancing is responsive to the kind of grassroots members that those organizations are responsive to is, I think, the most important thing we could do in terms of keeping our eye on the prize, in terms of building the political power we need to win eventually down the road. And I think we also have an inside game that we really need to think strategically about. I think there are definitely folks in EOIR, in the White House, maybe even in DHS, who are sympathetic to movement in this direction, and at the right time, kind of having the right inside strategy as well as the grassroots power is, I think, probably what gets us there.
I wanted to just say the words in re Galt, because I think we all focus on Gideon, but in re Galt is the juvenile right to counsel case. And I think one of the interesting tensions in this area is the tension between making these things less procedural and lawyer-driven and more sort of social worky, and which is kind of what happened with juvenile justice if you look back on that line of cases, and then ultimately it became apparent that what we really needed was a right to counsel for juveniles, and in fact it wasn't protective to send them to these juvenile reform facilities. They needed lawyers, they needed to be represented, and they needed to have their rights enforced. And so I think for me, one of the personal journeys I've had in working with Peter and the group that's been really working through this is I'm a civil attorney. I don't come from a criminal defense background, so I never conceived of this project ending up at the defenders. And partly what's happened in New York is the defenders all became much more sophisticated, partly driven by a more holistic model of defense, which they've now all adopted. But that wasn't who they were 20 years ago or 30 years ago. So, there's sort of there's a bunch of interesting things happening in this process. One of them is that we're now at least for the detained immigration, is it looks more like a criminal defender model. In fact, we're calling it a public defender model. But that's not how the civil attorneys at the table, at least the ones that I spoke with, began thinking about it. So there's a bunch of sort of journeys being taken on this path, and I assume it's going to have to be recreated nationally to get everybody there. But it's a really powerful one. It's really, really been interesting.
Hi, this question is for Peter, really, but it also builds on the public defender issue. I was just wondering if, now that there's this push for knife up, if there's an equal push with City Council and with other public defender offices around the country about the expansion of Padilla and the preventative arm and the mitigating arm in the public defender offices to prevent clients from actually reaching NIFUP, or to kind of create the record for NIFUP providers once they get there? And if you could speak to that.
Yeah, so, I mean, I know a little bit about that story in New York, and I've had some discussions with that story in other places around the country. I mean, frankly, New York was really ahead of Padilla, right? That we had a kind of the first Padilla units popping up at Legal Aid and Bronx Defenders and Brooklyn Defenders, and really in place in a serious way, and funded by the city as part of our criminal defense contracts because of advocacy of people like Robin Steinberg, who really kind of like said, we need this is essential to our mission, our criminal justice mission, we can't do it without it, and did the kind of advocacy to get those positions written into the contracts between the defenders and the city before Padilla ever came down. And the scale, when I started the immigration unit at the Bronx Defenders, and I was one attorney, and that was it. And I was fresh out of law school, and now I think there's like 14 attorneys, is that right, at the Bronx Defenders Immigration Unit, and Legal Aid and Bronx Defenders, Legal Aid and Brooklyn Defenders, and Queens Law Associates has somebody, and I think 2 people, and New York County lawyers have at least 1 person, and every defender office in the city, it's now kind of the norm. And so I know there's like continued advocacy around that. I'm not sure that there's a major push to kind of ramp up those services beyond where they are now. But I do know when I go around the country and have talked to other folks about kind of how we built this model, one of the building blocks that we used was to build off existing Padilla units. And I'm pretty shocked to learn how kind of underdeveloped those types of units are in other jurisdictions, even immigrant sympathetic jurisdictions in other places around the country. And I do think it makes a whole lot of sense for jurisdictions to kind of put their investment there first, because frankly, one attorney who can kind of consult on, several hundred cases in the criminal context per year can divert many, many, many people from ever landing in removal proceedings. So the idea that there's a ton of work to be done nationally on building out Padilla units, I think is absolutely right on. I think New York is in pretty good stead, and the state has recently made a real significant investment in making sure that what's happened in New York is not just in New York, but they've created these immigrant resource centers for public defenders all over the state. So we see what's happening in New York kind of building throughout the state, and there are other places in the country where it's happening, but not enough.
Question?
Yes, hi, Mary Meg McCarthy from National Immigrant Justice Center, and also with the ABA Commission. And thank you for your excellent presentations. I think, Lynn, you made a comment which it just continues to stay with me in terms of the need to get the public aware of the injustices that are occurring. And when I think about how we see more and more mixed status families and how U.S. citizens are being impacted, I just wonder how we can message this in a better way that engages a variety of stakeholders to move this forward. Unfortunately, I'm from a state that still does not have a budget in Illinois, so, the city of Chicago is in catastrophe too. So in terms of state or municipal funding, we're really struggling in terms of moving forward in this access to justice, but it's something that we have a little working group that's really trying to look at this, and like you in the Second Circuit, we have judges in the Seventh Circuit who are also interested, but we're kind of at a stalemate without funding to move it forward. But I just wanted to throw out that I know that the omnibus bill just passed or appropriated funding for a help desk, $1 million, not a lot, but in the immigration court. And I know we've seen this in Cook County and in the Northern District of Illinois, where help desks have really been helpful in moving people forward in their proceedings. Now, it's not ideal, and it has to be resourced with an individual. It's not a bunch of paper sitting there, but someone who can kind of help guide that individual in terms of what they possibly be eligible for, other referrals for legal services that are competent and not individuals engaged in the unauthorized practice of law. So I just wondered if you guys had thought about that or building that. I know there's a small help desk project here in New York. How you see that intersecting at all with what you've been doing?
my office both runs the largest free civil legal hotline, definitely in the city, probably in the state. So we have a lot of experience with giving brief advice to New Yorkers over the phone on civil legal issues, and then we're running this courthouse-based project. We have super experienced lawyers doing that work. So I think the tension on help desks, or whatever we want to call them, is how experienced can you put people on that? Because doing that kind of really, really fast triage, it's like being in a batting cage a little bit. The more experienced you are, the better you are at it. So the other trend in the legal community is really non-lawyer advocates, and it's a little bit like the community-based advocates who can also do a huge amount of really good work, but they tend to be better in a lane where it's already been defined what the lane is, as opposed to trying to figure out, what is this person's, big problem. So I think that's it might be interesting to actually set up two models, right, and look at one that is, the sort of non-lawyer community advocates that speak the language, that, get the story and maybe are supervised by a lawyer, and then one which is, super experienced legal, lawyers that do this. Because, they're running both of those in New York. In the civil legal area, there's both of those things going on in New York right now. There's both the lawyers that give out advice, and there are, for example, Housing Court has a table which is non-lawyers. And I believe Family Court has always had Family Court has two projects. One is non-lawyers, the lift table, and the other one is lawyers. So, there's both things going on where they're, trying to give people fast advice. I don't know what would work better in this area. My suspicion is it's so complicated that you'd have to be an experienced lawyer to do it, or someone who's under heavy supervision training, hooked up with a bigger network so they can pick up the phone and ask the question.
And with that, we are at the end of our time. Thank you very much. Thank you to our panelists.